not too many drinks tonight, that you have read the report and have a lot of questions tomorrow morning to make it a very good session where you get answers to all your questions. Now we're ready for the last session of today, for the last plenary, and I will invite one of the two moderators of this session, Jan Kleijsen from the Council of Europe, who will kick off that one. I give you the mic, and good luck.
Thank you very much. Thank you, Marie. Good afternoon, ladies and gentlemen. Thank you for having stayed at this late hour for our final session on emerging technologies and human rights. I'm very happy we have a cozy and intimate room to discuss, as well as a panel of high-level experts. Just a few words, perhaps by way of introduction. I represent the Council of Europe, an organization that I think many of you are familiar with, and which has been dealing, in fact, with the issue of emerging technology and human rights for a while. Several of you will know the Budapest Convention on Cybercrime, Convention 108 on data protection, and also relevant the Oviedo Convention on Biotechnology, which actually banned a new technological development, namely the cloning of human beings. Now, 3 weeks ago, we had our birthday party. We celebrated 70 years of Council of Europe, and our foreign ministers gave us a birthday present in the form of an instruction to start working on a binding legal instrument on the design, application and use of artificial intelligence, and to do so in a multi-stakeholder context. This is obviously a very new development, a new decision, and is therefore not yet included in the notes that we sent out for this session, but I hope that the questions that are put can be, of course, also examined in this light. It is a great pleasure, and I understand this is the protocol for the sessions, to call up to the podium first of all my co-moderator, Ms. Viveka Bonde from LightNet Foundation, one of the co-founders of the LightNet Foundation from Sweden, who will co-moderate, and then our panel of experts. First of all, Olivier Bringer from the European Commission, who's the head of the Next Generation Internet Unit. Please, Olivier, be so kind to join us. Lisa Four, the Director General of ETNO. Joanna Goody from the Fundamental Rights Agency, the Head of Data and Research. Joe McNamee, Council Independent Experts and one of our Council of Europe experts on automated data processing and AI. And last but not least, Mark Singers from Google, Program Manager for Research and Education.
Right, so we're now going to discuss emerging technologies and human rights. And first we'd like to pose questions, aren't we, Jan?
Yes, I just realized I forgot to mention the reporter, and I really apologize to Clément Perronneau from the University of Barcelona, who is and the Geneva Internet Platform, who is the reporter for this session.
Right, so we start with the first question. And I'm going to sit down here and I'm going to ask all of you panelists. We have now regulatory frameworks. What about any shortcomings in terms of these regulatory frameworks that exist? What are your views? Any shortcomings whatsoever? What are your initial views on that, your initial thoughts?
Thank you, everybody, for setting up this session. And I'd like to put out that, first of all, we have to realize the internet and the online space that it created is an achievement of the last 40, 50 years, and it hasn't broken down yet. We have never had to reboot it. So it is actually a surprisingly resilient architecture, and so many of the principles that it was built on were pretty smart and good principles: decentralization, open standards, things like that. Especially over the last 10, maybe 15 years, really thorny issues came up, and we will never find a solution that is ideal and that just is a clear-cut science answer to freedom of expression or privacy. These are things where we need to set up the right checks and balances, the right institutions to negotiate that. And overall, I would say we are on our way. Certainly, we would like to see institutions like the IGF play a better role in coupling the different efforts and institutions that make up internet governance and that shape the way that we handle these problems. But I'm not a dark seer. I think we should complain less and cooperate more on solutions. Let me point to the Internet and Jurisdiction Network that Bertrand de la Chapelle and Paul Fehlinger have set up. That really tries to bridge the debate and the deliberation around problems and brings it to something where we find solutions that are actually taking the perspectives and interests of all stakeholders together. Because what's very difficult to do is to come up with a transnational, a global network where you need to police and really try to understand how to get a hold of each small or big player, because there are so many ways to avoid and to frankly not follow the agreement. If it's not an agreement like internet traffic is exchanged, for example. I was really fascinated to learn from Andrew Sullivan, the ISOC CEO, that he said when it comes to internet traffic, there's only one rule: your network, your rules. And the way that the traffic is exchanged is by reputation, is by the interaction and the relationship that the exchanges develop with each other. And that works really well. I don't think that's always the right solution, but I think it's an interesting way to start to frame the problem and think about it.
Please, Joe.
Thank you. I think the thing that we miss most of all is a framework to learn from experience. We have a lot of experience in new technologies that are still called new, that have been around for a long time. In the committee that I'm involved in the Council of Europe, even mapping the issues that need to be addressed on algorithmic decision making between states regulating themselves, states regulating us, self-regulation of companies for their own processes, and increasingly privatized regulation by companies of their users. It's a very complex framework, but we're not starting from scratch, and we have a tendency to always think that we're starting from scratch. A wise man, I don't know who it was anymore, said that if you want to really seem to be up to date with the news, read yesterday's newspaper, because everyone's forgotten what happened yesterday. I'm going to be really, really up to date and tell you that on the 12th of November 1996, the New York Times had a front page headline: "Europe betting on self-regulation to control the internet." I have seen no document from anybody identifying the successes and failures of that approach from 1996 until 2019. There are things that have worked. There are things that have not worked. Law enforcement by private companies under the guise of self-regulation is a major issue for automated decision-making, for issues like content moderation. In 2015, the Council of Europe produced or commissioned a study on internet blocking, which showed that rule of law safeguards were not being applied. In 2017, the European Parliament passed a resolution castigating the European Commission for failing to produce data on the same subject. And we're still talking about self-regulation as one thing, when it's fighting spam, it's fighting illegal content, it's network security. So I think that fundamentally the thing that we miss is the ability to say, okay, can we not reinvent the wheel? What have we learned from privacy impact assessments that will help us on human rights impact assessments for algorithmic decision making, for example? Do we need to build from zero every time? And I think if we can learn from success and avoid making the same mistakes again, I think we're on the right track.
Thank you very much. Joanna, what's the view of the FRA on this?
Thank you very much. So I can only speak on behalf of the EU's Fundamental Rights Agency in the context of what's going on in the European Union. I mean, I think when we're asked this question, what are the shortcomings with the current regulatory framework? I mean, we've just heard from Jan Claesen there about the Council of Europe and their own initiative to look towards unifying law. And I think a lot of the discussion at the moment is between whether you have unifying single regulation, for example, or whether you are going on to a sectoral approach in terms of how you regulate emerging technologies, AI, the internet, you name it. I think we really have to understand what we currently have in place. I know there are exercises mapping the extent of existing legislation. Just in the case of the EU, we have very diverse legislation that is predating AI discussions on things like product liability. We have legislation from the 80s when really the discussion about AI was really off the map. We have legislation on product safety, consumer protection, you name it. If we take the context of the European Union, the most up-to-date and AI-relevant piece of overarching legislation is the General Data Protection Regulation. Because within that, you do have recognition for aspects of AI, the use and misuse of algorithms. So a lot of our legislation really was developed at a time that's pre-emerging technologies, pre-AI. But now, of course, we are recognising that, and the General Data Protection Regulation, which is only one area of law dealing with a specific right, is very comprehensive. The alarm bells were huge from the industry when that piece of legislation was on the table. Now people are calming down a little bit and seeing the added value of this legislation, but it only deals with a very specific, narrow area of law. And it took many, many years to negotiate. I've got a colleague from the Commission here who knows about that, but it is a comprehensive piece of legislation. So if we're asked what are the current shortcomings, I think we have to really map what we do have, its limitations of when it was drafted. Is it fit for purpose for emerging technologies and AI? But then I would say, beyond existing legislation in different fields like product liability, safety, consumer protection, we have human rights and fundamental rights law. We have the European Convention on Human Rights. We have the UN law. We have the Charter of Fundamental Rights of the European Union. The Charter of Fundamental Rights of the EU is quite a modern piece of law in that regard because it separates data protection and privacy. So you have now a modern instrument that is comprehensive that we can look at. And the much broader discussion about what kind of regulation we need in future is something where we need to know what we do have, is it fit for purpose, and then moving on from that, what is perhaps needed. However, of course, there is still great resistance from the industry about having any thought about regulation. Hence, the enthusiasm for ethics, which are non-binding, of course, and are a soft law option. And I can perhaps say more on that later.
Thank you very much. Now the floor to Lisa. You represent a body with many very diverse stakeholders. So.
Yes. Well, thank you, and thank you for inviting ETNO here. ETNO is the telco trade association for European telcos. And my members actually represent 70% of the investment in infrastructure here in Europe. So I will, of course, talk from a telecom perspective. And if I look at technology right now, what our members are doing, they're doing 5G, they're doing Internet of Things, AI, and cloud services are what they are concentrated with. And with that also comes all the things we're talking about today, emerging technologies and human rights. And things are changing because what we're seeing now is all the technologies are becoming more platforms and industries are becoming more interrelated. So I would like to take a step back and say, why is it technology is interesting for European citizens? It's actually because it's going to create a lot of changes to our lives. Part of it will make our lives easier. We will have online services that can help us shop, do e-governance, also remote surgery, etc. It will make it easier. It will also make our lives safer. We will have smart cities, we will have automated cars, etc. That will be safer for pedestrians, for drivers, and also for bicyclists. So why is emerging technology and human rights a problem? That's because technology will make us all traceable at any time. And we see that you will be connected, but also be able to the information you give away all the time will create new issues that we never foresaw back 10 years ago. So for us, human rights and shortcomings is also about privacy. It's of course about freedom of speech, but also security is essential when we talk about human rights. And we believe, a bit like Max is saying, we need to work together on this. So we need multi-stakeholder models to actually discuss and find out where are the shortcomings, because I also agree with Joanne that we have a lot of regulation already. We have GDPR that is regulating a lot of services, and that's a horizontal regulation. But we also, as telcos, have e-privacy, and e-privacy is very sector-specific. And for us, that's actually a shortcoming, because we think all regulation needs to be horizontal, because services are converging, and if we want to ensure human rights in the broadest extent, we need to have more horizontal views on how to deal with this. And we also think not only AI, but also IoT is really going to mean a problem and, of course, a lot of good solutions for all our citizens. Right now, we have 100 million connected devices if we take Europe and Eastern Europe, sorry. And we think we will have 500 million in 2023. So we will all be connected, and we will all have dependency on technology. And that's why anything we do needs to have the human rights aspect into it. Because if we don't, we will lose trust in technology, and that will actually mean a step back. But talking about this in Europe, we have one kind of regulation. If we look at the US, if we look at China, we have different regulations. And we need to have a balance where we look at how we do innovation on a respectful way, but also allowing for data to be used for AI, for example. So we think GDPR is a good start. We think we should look into how we can do some principles for AI. And the ETNO members are looking into, we think the high-level report that came from the Commission gave a good basis for this, part of doing good and do no harm, and also to have human autonomy in everything you do around AI. So I think we have a good basis. I think we need to build more on this. And I know we are going to talk later on how we actually implement any solutions.
Thank you, Lise. So Olivier Bringer from the European Commission. I would see two shortcomings, or rather two challenges for regulators in the digital environment. One is the time. The time of regulation is not the same as the time of technology, that we know very well. And in a way, we can try to accelerate the time of regulation. I think we have managed to do that in the current mandate. So with the digital single market strategy, we have managed to adopt in the field of digital 28 legislative proposals out of 30 in less than 4 years. So we can accelerate up to a certain point, I would say, because of course, when you want to go for legislation, you need to have time to prepare it well. You need to have precisely discussion with the multi-stakeholder community, preparation. You need to have good discussion with the co-legislators. So there is a form of incompressible time to issue balanced regulation. And the technology is not waiting. So the technology is going very, very fast. So the response, I guess, is in good part in anticipation. We need to anticipate the issues even before they occur. It means we shouldn't regulate before an issue occurs, but at least we should think about it, prepare well the ground, and this is what we try to do. This is what the Commissioner explained this morning. This is what we try to do in the field of artificial intelligence, for example, or blockchain. I think we are not late in these areas. We are really looking at the issues. What are the ethical issues that are raised by artificial intelligence in the field of blockchain? How can we maximize the opportunities of the technology? And we will see what are the next next steps. Then another challenge is that the internet is so broad. The internet is Google. The internet is one person who has a blog. It's someone who is selling whatever eggs or a pair of shoes on the internet. It's very, very broad. So it's much more difficult to intervene, to devise policies in this very large environment as it was when we started to do digital policies or digital regulation. I mean, Liz knows it very well. 20 years ago, we were mainly regulating telecom incumbents. In that case, in a way, it is simple. You need to identify someone who has market power, and you impose access remedies. When you regulate the internet of today, or when you do digital public policies, you have such a variety of stakeholders to take into account. And so one key issue, for example, is the size. We have issued regulations which apply to very different type of companies. They apply to very big companies, and they also apply to very small companies. So we need to tailor so that there is everything remains proportionate. That is a challenge. Very often we solve it by having different levels of obligations, depending on the size, depending on the turnover of the company. But this is something that we need to take into account, and also that we have very different players in front of us. And then last point, I would like to agree with what Joe said. I think we should avoid reinventing the wheel. Now we start to have a good corpus of legislation and public policy in the field of digital. GDPR is one. We have now some legislation on cybersecurity. We have started work on online disinformation. We should reuse, indeed. We should reuse the good concepts in the existing regulation in the next measures we will take. And I like your example of privacy impact assessment, for example.
Okay, thank you very much. Before asking Viveka to carry on, are there any questions at this stage, in order not to make this a one-way street, but to keep you all awake and entertained? Is anyone?
So while someone might be thinking about their question, I can jump in and make the panel a bit more dynamic by strongly disagreeing with what Joanne said about the current, what you say, kind of pro forma focus on ethics, and that companies don't want to participate in finding good governance, finding good regulation. I think on the first point, it's absolutely adequate to start with the ethics part, because that's when you understand what topics you should actually look into. So it's principles, it's ethics, and importantly, I think there's actually three kinds of ethics. There is virtue ethics, which is, okay, what does an individual player do? There's teleological ethics, where it's like, where do we want to go? And I think that's a very important conversation that we're having. What kind of a world do we want to live in? for example, in the case of AI, which I think is a really good example for where we can get it right. We're catching it early. We already have a fertile community of many different points of expertise. So virtue ethics, telos ethics, and then the teleological, the deontological ethics that usually slowly but surely become law or are based in deontological perspectives like human rights are another important part, but only one piece of the puzzle. And now I see someone with a question.
Please.
Hi there, my name is Colin Curry and I'm with Article 19. I find it really motivating that several people have mentioned impact assessments because I've been working with human rights impact assessment practitioners for the past year and a half to begin developing models and methodologies that could be applied to the ICT sector and to internet infrastructure providers more specifically. And one of the consistent challenges that we've had in transposing best practices that exist and have been applied in other sectors like mining, textiles, food and beverage, etc., this kind of supply chain focused impact assessment methodology has been that it requires, in order to be compliant with the United Nations Guiding Principles on Business and Human Rights, it requires a level of meaningful engagement with affected rights holders. So when you talk about internet infrastructure providers like everything from registries, registrars, undersea cables, ISPs to platforms, it can be very difficult to lasso this constituency of who would be an impacted rights holder, and it can be even more difficult to actively engage with them on the potential impacts. So I think it's really important to underscore from a practitioner side that this is somewhere where we fall short within the internet community, and I think that it's a bit premature to refer to the work that's being done as an impact assessment, just in the interest of not diluting the practice as it exists and has been more formalized in other sectors. So I wanted to pose the question to the people, specifically the people who had mentioned this as a potential solution or an avenue to be explored, if they are engaging with the people kind of on the ground who are actually trying to make these methodologies and best practices applicable to our sector.
Okay.
Could I come back?
Jenna, please.
I will also answer the point you've made, but I thought I should respond because it's always good to have a challenge from another panel member, but I'll also draw on what you've just said. I'm a member of the European Commission's high-level expert group on AI. So I'm one of the 52 members. So when you thought the UN expert group is large in terms of working with a diverse constituency of stakeholders, also with civil society, that's a very large group. I just want to underline, because I was challenged, the work of this specific group. It puts three pillars there. It puts ethics, law, and robustness. And it really says all three, ethics, law and robustness, need to be looked at as one whole. So it's not that you say ethics is the way to go or law is the way to go or indeed robustness. It's the package, it's the whole three together. So that's a point I very much want to underline. So it's not an either or discussion. Law and ethics are very closely intertwined, but the heading of this group is emerging technologies and human rights. And human rights are very much legally based. And what I want to reply to the person who just gave the intervention there is I think the point you make about impact assessments is very much about the whole life cycle of, if I speak only about AI, for example, developments, who is consulted from the very conceptualization through to the rollout and ex post evaluations in terms of what you're talking about. And you mentioned business and human rights, but we're currently at the stage in relation to business and human rights. We're not binding. They're not binding in the sense of one when looks at general data protection regulation. So there are different levels of legal oversight and governance in that regard. So my understanding in terms of the emerging work of the Commission's high-level group on AI and trustworthy AI is the need for that multi-stakeholder engagement at all stages of product development. This is something that the high-level expert group of the Commission on AI is about to pilot with different sectors. So they're actually going to be looking at the application of the checklist they developed on trustworthy of AI with industry and with different users, which is so important, or else it's theory and it doesn't look at the practice in reality, which I hope is gelling with a point that you raised there.
Lisa, please, you wanted to come in on this one too.
Yeah, because I actually like the question on impact assessment, because for me, impact assessment are key. They're extremely important. But what we see at the moment is impact assessments are, first of all, very academic, because we're not widening the scope. Plus also, we're too technology specific. So if you talk about AI and human rights, you might forget the IoT angle or the 5G angle, and all these things are converging as we speak. They're all interdependent, and it's extremely difficult at the moment to actually make an assessment that is fulfilling, that will give a good picture of the actual impact. So I'm a fan, but I'm just saying we need to rethink how we do it.
What about issues of enforcement and supervision? How do you consider that to be done, considering the challenges we have in the different markets and the different kind of technologies as well?
I was just thinking that Max could give us an example of something that Google did over the last 5 years, that looking at the high-level expert group ethics document, you would not do again in similar circumstances. Then we can see a real-life example of how it would impact our rights and freedoms.
Wow, that's a very difficult question. So while I respond to Joanne and try to answer the question that was posed, I'll think of something that we might not have done again, or we might not do again. I think to your point, I really like the three aspects or the three pillars of robustness, law, and ethics. I would say that the ethics is really the virtue ethics, the understanding what we are doing as practitioners. The law is what the stakeholder group of governments clearly are in the lead for. So they will consult with other stakeholders. And similarly to the impact assessment question, I think, yes, of course, companies should self-assess, but it's actually independent assessment and outside assessments done by NGOs, by civil society, by other stakeholders to look at the practice that are most interesting. And allow me to just, to underline why I think AI governance is something where we see a next generation, a more mature multi-stakeholder governance approach and responsible innovation by certainly the leaders in AI, that they bring the academics and the researchers together for the kind of principles that are identified. And I'm not going to read all the AI principles from Google to you, but three that I find particularly interesting and actually not pushing away responsibility are in the AI governance paper that was released at the World Economic Forum in late January, early February, and that is explainability, really make it possible for others to understand what this somewhat autonomous machine does. Fairness appraisal, make it transparent and discuss what factors, what weightings go into the machine as it's developing its model. And then really they are asking and proposing that we need liability frameworks for AI, which I think is incredibly important and really points to the need for good regulation in that space. And one last one I wanted to point out is accountability to people. It's called human in the loop, and I think it's actually a fairly difficult one to achieve. So by no means are we chickening out of the difficult questions. I think, they're big questions and they're not answered yet, and nobody on the planet knows the answer, so we should do it together.
And I'm coming back to the question then of enforcement and supervision in that perspective. So how would you consider that on not only where we are now, but also where we are heading?
Joanna, please. I think there's a mic over there.
I mean, it's hard to predict where we are heading, but if we look at the European Union at the moment, we have, for example, a number of agencies that are responsible for oversight and enforcement in key areas where you can do harm. And one can also think about emerging technologies and AI in that regard. So, for example, we have a chemicals agency that regulates. We have a medicines agency that regulates. So lots of different models that exist, but they're sectorial for different areas. We can also look at ombudspersons. There are different models that are out there. And I think we can draw from experience of areas where we've decided that we need regulation because the impact on humanity is so great and the potential for harm, but also the potential for good is there too. And I think we really can learn from models and our experience in different areas to see what would perhaps fit best if we're going forward for AI. But again, it's the point I raised earlier. If you are going to have oversight, if you're talking about hard law, you will of course need to have not just NGOs overseeing, you will need to have proper organisations that have the legal weight to do that. And it's a very different scenario to talking about self-regulation, optional ethics, and other guidelines. So we're talking about different things, and I'm not sure what you're asking about, the soft law or the hard law aspect.
I was thinking both whether how to strike the balance between soft law and hard law, really. And do you need both?
The big problem, though, is that there is no such thing as an internet industry, really. I mean, you know, Amazon is doing something completely different from the telco organizations than from Google. So it's more that, you know, the internet is eating the world, that everything becomes internet governance. And that's why it's so difficult to say there should be one, you know, institution that is an industry regulatory body. I think it's almost the other way around. We need all the bodies to understand what the internet is and how it transforms their respective pieces, and then we need places like the Internet Governance Forum where that comes together and is loosely coupled, so that we make sure that we're not, you know, seeing things fall through the cracks.
Lisa, please.
Well, we know, and we are talking about that technology is really developing rapidly, and it's extremely difficult to keep up with what's out there. And I agree that internet is actually eating the world, but for the industry, it's actually key that we ensure, and I think this also is the same for any user, that we have some predictability and some certainty. So whatever is going to be the end result of any framework for AI, for Internet of Things, for 5G, whatever, is actually that we need to ensure that we know what's there and we're avoiding fragmentation. Because in Europe, we have 28, maybe 27 member states, and we don't want to have different rules in every member state. We want to have the same, and that will also be easier for the end users to relate to, because they would have one system. Again, that being said, the world is not going to follow Europe per se. I know GDPR made a huge effort to actually harmonize privacy rules all over the world and has set a great example. But I'm not sure we can have the same success with AI. But we need to be sure that we balance any framework we do with the ability to actually also develop, because the European citizens will anyway use services that comes from US, that comes from China, that comes from all over the world. So we need to be sure whatever we do, we don't fragment Europe, and we don't fragment in relation to the rest of the world.
Lisa, just to disagree with one slight thing you said. Of course, seen from Strasbourg, Europe has 47 states, not 27 or 28. Joe?
I was struck when I was reading, first of all, I think we should keep remembering what Joanna said in her opening comments about the role of law in fundamental rights and the guarantees that it provides. I think we need to look at some examples. In the ethics group document, there are numerous references to fundamental rights. But fundamental rights are the responsibility of states. States have an obligation under the convention, under the charter, to ensure these rights. That doesn't mean they have to be done always by hard law, but it's the role of the state. Now, let's take a practical example of our freedom of expression rights in 2019. The European Commission, in its terrorism regulation and its, dare I mention, the copyright directive, changes the balance of incentives of internet companies, making it more attractive to remove more content than to leave it online. This is not an obligation being imposed by the European Commission. It's a new framework. So then more is deleted, more legal content will be deleted. The European Commission in relation to existing content removal is dreadful in data production, as the European Parliament's resolution on child exploitation in December 2017 described in painful detail. And what happens once Google, as a company that has the resources to deal with such a complex new framework, how does Google react, let alone a small company? And we see, and it's nice to talk about transparency and accountability, but look at there's a women's rights organization called Women on Waves. Every 10 weeks, their YouTube channel is deleted through malicious gaming and put back online eventually, and put back online more slowly, and then more slowly still, and then more slowly still. So where does a citizen, a European, proud European looking at the Charter of Fundamental Rights, restrictions on fundamental rights may only be imposed if necessary, proportionate, genuinely achieving objectives of general interest and provided for by law. Those are wonderful, strong words, and I'd love the European framework on human rights. But it's falling between all of the cracks. The Commission is avoiding accountability. Google and everyone else is avoiding accountability. And suddenly we find ourselves without the rights that are hard law in the international legal framework. Perhaps you can tell us about the transparency and accountability and reactiveness of Google when you remove content.
So thanks for that second question. I did come up with an answer to your first one, which is what I would have done different, what I think we could have done different. I think we let a real big opportunity pass when we decided to invest in Google Plus rather than pursuing Open Social, which was an open standard for digital identity, which is one of the missing pieces of internet architecture. If you come back to my original statement that, that architecture is not bad, but that's a missing piece, and we kind of let that go. There was an initiative to provide standards for digital identity. Now, on your second question, how do we do these things? I think, appropriately, the colleagues from the Commission talk about law and how to make policies. So let me speak a little bit about the tool set that companies have and apply, and what we do. So basically, there is commitments that we engage in, most notably in the context of human rights, the Global Network Initiative, GNI, which is a fairly established tool at this point, and it goes slowly, but it does make progress in terms of asking first to report and do a self-assessment and report about that, and then you get independent reports, and that's already really helpful, really, to get the internal wheels turning and have the conversations about what we do and what we should do. So that's helpful. The second one is commitments like principles, and then the research that I've mentioned. Then I think it really comes to setting up the internal infrastructure to address these points. There is internal committee for emerging technologies that gets together every quarter, and the engineers report about what they want to invent. The proposals get discussed by our ethics council, things like that. And then last, but really importantly, there is the public scrutiny and participating in the questions that we get posed and that make us think about how to get this right. Now, when we're talking about freedom of expression for user-generated content, that's a really, really difficult question that you cannot get right for everybody. You will always make one party or one group unhappy that want more freedom of expression, and the other group wants more paternalism and more control over what's generally seen. I don't think we have found the solution there, but I do think that we're on our way to getting better, to having checks and balances that, for example, you can contest when things get flagged. You need, of course, different layers of content governance, if you want, where the first one is user-generated content needs user-generated governance, right? A lot of things should be dealt with the users that are using, that are offended by the content, that are and communicate about that. A second layer brings in the company that tries to resolve those issues, and then of course there needs to be a public infrastructure that addresses the cases that can't be resolved. Hopefully that's only 1/3 of them, because we're talking about many, 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 many cases.
Perhaps before giving the floor to Olivier, may I just raise an issue here, following what Marc said. The Université de Montréal and McGill are doing a mapping exercise, and they've come up so far with 60 ethical charters around the world relating to artificial intelligence. And those include the one recently issued by the European Commission, OECD, and 58 others. That raises the question, however, is whether these self-regulatory instruments are sufficient in combination with some existing law. We already heard GDPR, but of course we have Convention 108, we have the Cybercrime Convention. For European countries, there is the European Convention on Human Rights. But is that enough? I'd be very grateful if the panel if we could move a bit perhaps also into the area more specifically of AI, because of course emerging technologies is a very wide topic. But if we can perhaps, for the benefit of this debate, focus a bit on AI. Please, Olivier.
If you allow me, I will still reply to the previous question. Just to say, in terms of enforcement and supervision, we have to distinguish between indeed legislation or hard regulation and softer approaches like self-regulation. In the case of hard regulation, I think there is a very important role for national regulators. So it's very important that these regulators are well-staffed, that they are independent, that they can do their work properly. And again, here, we don't need to reinvent the wheel. We have already sectors where regulators have been active for a long time, where they are really effective. It's the case in telecom, it's the case in data protection authorities.
Any specific sectors you're thinking of there that you want to make a comparison with? Any specific sectors that you want to compare AI and advanced digital technologies?
An obvious one is, again, it's because a lot of the issues on AI and ethics will be about protecting the personal data of individuals. So I think the data protection authorities have a big say in that. Something which is also important is the mechanism for cooperation. So the fact that all these regulators meet and share best practices, how to implement the rules, often the European rules. Another thing I think is are the skills. We need to make sure that, so it's not only a question of all of us acquiring basic skills, it's also the policymakers, it's also the judges who need to acquire the skills. They will need to acquire the skills about artificial intelligence, for example. And this is happening. I mean, we see it, that in sectors which were remote from digital 10 years ago, the policymakers are acquiring the skills in health, in transport, in public government services. And when turning now to self-regulation, I think one important thing to do is really to ensure transparency. So it's very good to go for a self-regulatory approach, but we need to be able, everyone needs to be able to monitor it. And that is a mechanism that should be enshrined in the self-regulation approach. And this is what happens, for example, if you look at what we are doing now on online disinformation, we have a code of practice, and every month, those who have signed the code of practice issue reports on how they have applied it, how many fake accounts they have removed, etc. So I think that is a very important aspect, and in the end, it's also the role of the public authorities to look at the results. From time to time, we need to look if the self-regulatory mechanism deliver or not, and then take our responsibilities if it does not. So these would be my ideas for enforcement and supervision, and then I would like to reply to Joe. I think Max partially replied to you already. I mean, yes, in several of our regulation, we have imposed that certain content, for example, that would infringe intellectual property or that would infringe other rights or laws need to be removed. But we have the possibility to contest. So there is always a possibility for someone who has seen the content removed in a non-justified manner to contest in order to get their fundamental rights respected. So, for example, the freedom of speech, or because they want to have their data protected, for example. So there is a balance. There. Probably the details, how it's going to be, how this balance is going to be implemented practically. This is something that can be done via the multi-stakeholder process too. So by putting the platforms who hold the content, those who hold the rights in the case of copyright, the fact checkers, etc., together to see how this mechanism can be of notice and action, and counter notice can work in practice. And then on your point, sorry, on artificial intelligence and the 60 rule books on ethics. I mean, we are at the start of an international dialogue. So very clearly, for example, in our strategy in the European Commission, we have said, okay, this is not something we can do on our own inside the European Union. We have to open up. We have to discuss inside the G7, inside the G20. We have to discuss inside the Internet Governance Forum. We have to engage with the Council of Europe. So I think part of the reply is in the idea that we need to put in place the international dialogue to agree not only on the principles but also how we are going to apply them. Because if you read, I did not read many of them, but a few of them, and there is good convergence, I think, in terms of the principles themselves. I think the difficulty will be in their implementation, and the risk of divergence is really there.
Who else would like to comment on this, either from the panel or from the audience? Please, Lisa.
Your question on if it's enough, the current regulation or the current frameworks we have, I think it's a difficult question because, again, I'd like to come back to my prior statement on, I think we are looking into AI that will converge, that are used in many different industries that we never thought about before. So now AI is used in farming, it's used in health industry, it's used of course, in the telco industry, and also Google uses a lot. So we have different uses of AI, and I'm not sure that we can regulate this in a way that will cover all of these kind of uses. And I'm a strong believer in that we need really self-regulation here, and I think the industries will have big problems if we don't do it anyway. no matter what happens with other regulation, everyone needs to be very transparent on what are your principles for AI and how do you deal with data, because people are getting much more aware of the use of data and much more confident in that the data is theirs. And I think GDPR has a great influence in this development. But also, if we are to do any further regulation, we need to really take in all stakeholders and have a multi-stakeholder approach to this, because otherwise we lose parts of what's important in regulation of AI.
Thank you.
To underline that point, just to see AI in healthcare is something where we apply the rules of healthcare that are very, very strict in terms of how you can innovate. While traditionally on the internet you have a permissionless innovation model where everybody can bring on services. So if you take those two extremes, that's what we have to bridge, right? It's not a one-size-fits-all approach, and you don't regulate AI. Lisa, I really like that fundamental point. What we do want to do more, I think, is apply real-world metaphors. When I come back to your point about freedom of expression, you have very different expectations about freedom of expression, whether you are in a place like this, whether you are at a party somewhere in a club or something, or whether you are in a legal hearing, right? Those are very different conditions, and what we should do is we should agree on the principles and make sure that human rights are always looked at, and that's where your national individual agencies come into play to monitor, probably based on information and intelligence that civil society, that users bring to them. And then we find different community agreements for how you address it in those different environments.
Joe, please.
I can't help wondering what any one of the 1.6 million patients who had personally identifiable data donated by a London Health Trust to Google DeepMind would think about the last statement. I suspect they would be sick.
I mean, obviously, I apologize for that mistreatment. That's a long time ago, and that was before a lot of the work and a lot of the infrastructure that has grown since is developed. Again, that was a really bad incident.
So on that note, if we look at AI in respect of human rights, and we look at the creation of AI from the data collection stage down to the design, development, and deployment, how can we ensure the human rights element with self-regulation? How can we do that?
Joanna, please.
Well, I mean, really, self-regulation only takes you so far. So beyond that, you have to have regulation which deals with hard law, and it's the duty of the states to ensure that the law is enforced. And we do have human rights, fundamental rights laws in place which need to be applied, and they're very broadly framed. And so they can also be applied in the context of emerging technologies and AI. And then we have to see if they're fit for purpose for the advancement of technology. One thing that was raised, if you're talking about self-regulation, is the point of redress and access to justice. So my fellow speakers, just on my left here, your right, talked about a data breach. And we have many examples of this in all different industries that are emerging. Now, for the individuals concerned, it's very hard to get access to justice and redress. So if we're talking about a right, this is a core right, and we have to look at ways in which mass breaches can be addressed, and that's only one area, is a data breach in that regard. So we really have to say that the companies can only address that so far. They can try and prevent it, they can try and fix it. But when there's a serious breach, for example, a data breach, it has huge, significant implications for individuals concerned. And for that, you really need the weight of the law to make sure that redress can be met. And that might mean eventually going to court, it might mean penalties, etc. Self-regulation can only take you so far. And I think some of the examples today are talking about a continuum of impact of emerging technologies and AI. The examples that are often given is, online shopping, what's the problem with that? Versus the impact, say, on your personal health and whether a decision is made whether you get treatment or not. So whilst it might not be a one model fits all in terms of the weight of oversight, I still think that the human rights founding principles apply regardless of the level, and that has to be made very clear. So there's not a hierarchy at which you suddenly say human rights don't apply or they do apply. And that's where self-regulation, you have to go beyond that, because that's really the role of the state and international bodies that look at the governance.
Thank you very much, John, and also thank you very much for having put on the table the issue of remedies, because I think that is a very crucial element. Question from the audience, please.
My name is Jutta Kroll from the German Digital Opportunities Foundation, and I have more a statement and then a question. You have made several references to the GDPR, and this is the first time we have a data protection and privacy regulation that is age differentiating, that explicitly addresses the children's rights to privacy and data protection. And so my question would be, with reference to Lise, who has mentioned the multi-stakeholder approach, what do you think about especially addressing children's rights in regard of regulation and self-regulation towards emerging technologies and especially AI? Have you any thought about that? Is it in your mind? Not only to Lise, but to all of you. Thank you.
Children and perhaps other vulnerable groups too, please.
Well, I actually think it's a given for emerging technologies, because if we're not, with the extended use of technologies also among children, we just need to take into account their rights. And I think it's extremely important, even also in a multi-stakeholder model, that you include the young, not necessarily the very young children, but you include young people, because we tend to have a certain age level in a multi-stakeholder discussion, and we need to ensure all the full spectrum of ages are included.
At a hearing yesterday in Strasbourg where companies were represented, the observation was made that the over 10-year-olds, the between 10 and 21-year-olds are okay. It's anyone that's over 21 that's the problem.
So Jutta, I really like your question. Thanks. I think what's good about it is that the hardest problems are of course those where the challenges become most obvious, but when you've solved them, you've actually a blueprint that's good for a broader picture. In the case of children, I think what's really missing is exactly the digital ID, the age verification that needs to come at one point where I don't know when and how it can be applied. Similarly, health is a wonderful question when it comes to data sharing, because actually, innovation, and that means finding cures to deadly diseases and to treat us all, are not pursued because the data regulations are so clunked. So we have a saying that data protection plus data sharing becomes data governance, and that's what we should be really thinking about, plus identity.
Max, can I just prod you on this one, on this reply, just a supplementary question, because at Google you also deal with education. Now, digital literacy and AI literacy surely must be a very important element in empowering users to use their rights, to make use of the remedies they have. How do you see this issue? Because this has been pointed out in several of these ethical frameworks. I mentioned several of the 60s, of these 60 charters. I haven't read all of them, but also I've read a number of them. There is this issue of the obligation of states and companies to ensure that users are, the citizens and users are aware, for instance, when they interact with AI?
So there's two sides to the question and to the literacy and capacity to know. One is really on the developer and on the expert, making sure that the technology is doing what it does in terms of emerging technologies. Here I mentioned the explainability factor already, where you have to understand why an autonomous system is making a decision, at least in principle, and then it has to be taken back. The other one is really about agency and what we call in German Mündigkeit, so coming of age, right, to be literate, to use a certain technology. And I think, to be frank, Google could do even more than we already do. We do train or have trained more than 100 million people in digital literacy skills, but those are more job-related skills to address the challenge of the workforce needing those digital skills and to improve there. There is an equally important, I would argue, capacity of really using media, of participating in media. But again, I don't think this is something that any player can do by themselves. It's a constellation of using the existing educational system, of course, and then again, it's a funny catch-21 where when Google does something, they will say, "Oh my God, they go into the schools." When we don't do something, they say, "Oh, how can they not do something?" So I think it's a middle path, and we'll find a reasonable solution.
Thank you. I don't know whether there's anyone from Finland in the audience, but Finland, apparently, the government is offering a free online course on AI literacy in this respect. Question from the audience, please.
Yes, thank you. Marianne Franklin, Internet Rights and Principles Coalition. I'm speaking in terms of time, which is what Joe reminded us of. When do emerging technologies become emerged technologies? Once upon a time, the web was an emerging technology. Artificial intelligence is not a new issue. So I would like to hear from each of you, if I may ask, a clearer definition of what you mean by artificial intelligence. Because we're talking about possible beings that might one day wish to have human rights. But we're also talking about simple automated programs, perhaps. So I'd really like to hear specifically what you mean by artificial intelligence. What you mean by emerging technologies here and now in 2019. And thirdly, where would you draw the line in time terms? When do your emerging technologies become already emerged? Because I think we're wandering around history as if everything has stood still when it kind of tends to go back and come back again. So thanks for being a little bit pedantic for me, because until we get our conceptions clear, our conversations will go nowhere. Thank you very much.
Thank you.
If I can first come back to a question that was asked a while ago about self-regulation. I think I would like to reiterate what I said at the start. Sometimes self-regulation has worked. Sometimes self-regulation hasn't worked. The times that it has worked tend to be similar for various reasons. The times that it hasn't worked, it's tended to be similar for various reasons. Call me an old cynic, but when there's a self-interest of the company that's self-regulating, it will self-regulate better as a general rule. So the first thing that we can do is look at our experience and say, okay, on this end of the spectrum, we know from experience that we can rely on self-regulation. If we take something like network security, we know companies have an interest in having decent security. We know that they would prefer not to notify a data breach. So having a basic level of security which can be exceeded on self-regulatory basis makes sense. Allowing self-regulatory data breach notifications, that's not going to work. So the evidence is there. We just need to use it. On the education question, I'm personally horrified. I saw my niece's tablet, and it scared the hell out of me. And then Pat Walsh, who was involved in the mobile industry, did an analysis of one of the apps, which is of very little value to the students and huge value and huge long-term value to the companies. And it's just not good enough that, this is being given to kids without discussion with the kids, without discussion with the adults. Consent, meaningful consent, it doesn't exist. On emerging technologies, I think I avoided using both the phrases emerging technologies and the phrase artificial intelligence. I would agree with you. There is a, dare I say, lobbying imperative to restart the clock every year, but there's no practical reason to. So technology isn't going to stop. There's always going to be emerging technologies. But if you look at the European Convention on Human Rights, that was written in 70 years ago, and it is as valid today as it was 70 more, probably. We don't need to reinvent it. We need to continue to adapt it and live by our principles and not live by headlines.
Replying, to the question of that you asked about emerging technologies, I will let maybe Joanna, if she has the report, to define what is artificial intelligence. I will not try definition on the spot. On this issue of emerging and possibly at some stage emerged technologies, I think, we don't know as policymakers. We cannot be sure that the technology will really eat the world, as Liz was saying. So we have to be quite modest. The best we can do is to have a discussion with the experts, is to have a discussion with the community, to try to understand where the technology is going and what type of framework is required to make sure that it delivers what it needs to deliver to the society and to the economy. So I think we have to be, as policymakers, we have to be modest, and we have to be adaptive to precisely to adapt to the emergence of different technologies. And the second thing I would say is that if we want to understand that well, we have also to use another instrument, which is investment. So policy is not only about regulation and different flavors of regulation. Policy is much more than that. I'm managing an initiative, Next Generation Internet, where we are investing in the technologies of tomorrow. This is an innovation initiative. This is an investment initiative. And with this type of initiative, we can understand the technologies. We can understand what is exactly the state of art, where it's going, where we need to invest, where we need more, where we need to intervene. And I think this technology angle is very important. If we want, in the end, to have the artificial intelligence that we want, which is in line with European values, if we want to have a blockchain that is truly decentralized, we have to invest in the technologies here in Europe. We have to help the innovators who are developing the technologies. Otherwise, the technology and the values that come with the technology will be imposed on us from the outside. So I think the competitiveness, the investment angle is as important as the regulatory angle.
Thank you, Lisa, and perhaps then also Joanna afterwards, because there was a definition in the high-level group of AI.
I don't think we're repeating ourselves, and I don't think this is of no use. I think it's extremely important we start these discussions now. What has been in the past about AI has been more machine learning. It hasn't been real AI. And I agree, we call a lot of things AI, but actually what we start to see now are the first steps towards AI. And together with other technologies that are truly converging, like 5G, which is actually conversion of fixed and mobile networks, we actually are moving into an era now where we don't know where things begins or ends, because everything is going to be more and more interdependent. So I think these discussions are extremely important, but they're also important that we take them, as we keep saying, on a more horizontal level. Also, what we see is other industries moving in to the technology industry. So everyone is now becoming very dependent on internet, on AI, on being connected at any time. And to Joe's example of some of the companies misusing data, we will also always have bad apples in the basket. And I don't think regulation will solve it. It will, of course, give a clear framework, but I'm just not really confident that we can solve it all by regulation. What we need to do is raise awareness and raise transparency and educate the users.
Thank you. Joanna.
Okay, I think the interesting discussion is, on the one hand, is the onus on the users having responsibility, but the companies have responsibility and the state has responsibility too. I think most responsibility can't be put on the user, is another thing I would say. There are multiple definitions of AI out there. You read any documents and they're all slightly varying. I have one that happens to be in front of me from the European Commission. I am not going to read it out. It is very long. And if I read it out, it will be contested naturally. But I think when we talk just about the label of AI, it is so diverse, and some of it we are all aware of. It's in our everyday lives, and we open up our smartphones and it's being used. But what is very interesting, if you look at areas like bias or discrimination in the application of algorithms or in predictive policing, and areas where people have written a lot about this and are very concerned, is that you can go back to the 80s, where already issues about bias, predictive policing, data was being gathered, but we didn't refer to AI. But the same basic principles of discrimination and bias, unfair treatment, were already being raised by people working in this field. AI is a new tool using a lot more data, but more data doesn't equate to better quality necessarily. So I think we can really draw from our lessons, from our established critique, from a human rights perspective, fundamental rights perspective, and apply it to the new tools that we have through AI. Sometimes, though, when I read what's going on in AI, and particularly in the field of robotics as one example, a lot of it is still science fiction. So I think a lot of AI is here and now. We're all very aware of it, but a lot of it, there are a lot of alarm bells ringing, and we have to be very pragmatic. We have to have real use cases. And the one point I'd really like to underline is less theory and more diving down into these use cases and what is actually going on. Because then we can pinpoint real fundamental rights issues in the conceptualization of it through to actually getting redress if something goes wrong. A lot of the discussion is very high level at the moment, and I think we would really help ourselves by grounding it in much more transparent understanding of the uses to which AI is being put. And that's, I think, the stage we'll go to next as well.
Thank you very much. Max, please.
Marianne, thank you very much. Let me try to give you what's hopefully a pretty precise and helpful answer. I think AI is a fairly blurry term, but I'm going to end up with something that's very concrete and that I think is at the core of what we should be talking about when we talk about governance and regulation. Of course, AI is the machine learning that was discussed in a number of things, and then there's general AI, which doesn't exist yet and is pretty far out as far as we can tell. But there is one element of that AI question that I think is cross-cutting, independent of the sector and of its application. And that is that it takes autonomous decisions. And so if we're framing the conversation more about, what decision is being taken and, how can we understand how it is being taken, then I think we're on a pretty good path to thinking about how to govern this space. It's in the end about agency, right? It's about we're giving up our human agency, and you could imagine an AI voting tool, right? There is a German tool in Germany. There is a tool on the internet where you can answer all the questions and it will tell you what you should vote. Right? I mean, take that to the next level, and you tell the AI everything you know, and then it will vote for you. Is that, you see what kind of questions you're getting into here. I think more generally, there's two kinds of technologies. There's technology of access. You get access to Wikipedia, to knowledge, to means of, that augment yourself and your understanding of the world. And there's technologies of control. It's also a really good thing when you want to control a production chain. You want to ensure that there's certain aspects of freedom of expression, etc., controlled. Then that's what you want. I think it's the balance between the two, and they're actually both there when you think about AI. If it's a technology of access, then it's something that augments me, and that should be loyal to me, and is kind of the answer to the question, oh, there's such an imbalance between the enormous AI systems out there and me, myself, who am I to understand all of that? I think if we get good systems that are on our side, the individual side, and augment us with AI tools, then that's a good thing. Now, let me address the second part, at least from Marianne's question, and that is about emerging technologies. I think emerging technologies are technologies where we don't know the exact outcomes of what is happening when we apply them. So we have I would argue there's some applications of AI that are not emergent anymore. We do know what's coming out, but then there are many that we don't. And we actually, at Google, we changed the way that we roll out these technologies because it's different. It used to be that you write a nice blog post and you say, now for everybody to try out beta phase, new Gmail, a new mail program called Gmail. It was in beta for a very long time, famously. That's not how we roll out AI-based systems. We take small groups, we test them, we iterate, we add different diversity aspects to them, we change the settings in which the technology is used. And it's a much more conscious, much more responsible, I would say, in this context, effort. And so I'm very much a fan of defining this, what we call emerging could be defined as beta. And to have a very clear distinction between beta technology that, for example, can only be out for so long, that has certain characteristics, right, it's more experimental, and mature technologies where, for example, on beta you can't make money, all technologies where you make money, at least at a certain conditions, right, that should be not in beta anymore, because you have to be responsible in what you put out as a real product. If people sign up for something and they want to be part of an experimental community, that's a different contract between the user and the provider of the service.
Thank you, Max. We are running out of time, unfortunately. Final question for you. Are there any democratic oversights when it comes to emerging technologies? Any such aspects you would like to share?
I would really, really like governments to apply their existing electoral advertising rules to internet advertising. In the Irish abortion referendum, you had a ridiculous situation where the Irish government didn't consider it relevant to have the same rules for online advertising as offline advertising. Google took, I think, a good decision, forgive me for saying something nice to you after all of this, to not accept advertising after a particular moment. Facebook decided to not take non-Irish sourced money for advertising, which was pathetically easy to circumvent. So the government didn't regulate at all. Facebook regulated one way, Google regulated another way. That's not grown-up politics in this era. So if we could at least have consistency, that would be. It's not exactly what you were asking, but it annoys me.
No, you can just add the democracy into that.
Democracy.
Who would like to come in before we move to the final rounds of comments, given the time?
So I think, as this is the European Internet Governance Forum or Internet Governance Dialogue, it's important to see that, somewhat this is a technocratic conversation, and, nobody, I don't think anybody was really voted and has as such a legitimacy in terms of democracy. And I'm not sure that it would be helpful to, have all these different stakeholder groups vote and introduce democracy in that way. What does seem like a very good proposal is to include the view of the people, and that is an informed view of the people in our debates, and have that as a base to come back to. And it's a practice, citizen deliberations, that's quite developed. There is a project underway to bring that to internet governance by a French NGO called Mission Publique. And I think that is a really good way to have democratic values and practices in a multi-stakeholder context. It also has, if you allow me that last point, it also has the advantage to give you a delta between what people say off the street when you just go out and ask everybody, and what they say after they have deliberated and spent time and weighted the trade-offs between the different options. Because if you see that that delta is pretty big, you should not go with the general sentiment and just go around and ask people what to say. Privacy is unfortunately a really good example. At this point, everybody says, it's very bad and we need to do something. But that's not really helping, because it's not a constructive way. So you should not go out in a democratic way and ask everybody what to do. You're not going to get an answer that's going to work on the pretty complex environment with legal, technical, business, different cultural aspects. So I do think that the multi-stakeholder governance approach is the right one, but it should be informed by democratic practices.
Olivier.
Yeah, so on this, I would simply say that the democratic oversight is enshrined in our institutional setup. I mean, when we devise regulation, when we devise policies, we do it together with at European level, together with the European Parliament, together with the member states who represent the people. So there should be a democratic oversight, of course, and it already exists via the institutional setup. And the Parliament, yes, is, for example, the Parliament last year or 2 years ago issued a report on artificial intelligence. So it looks into these issues. I'm pretty sure, for example, that the next Parliament, which is now being installed, built up, will look at those issues, and it will be on their agenda. And I fully agree with Max. If we want to discuss these issues, it's a bit like discussing Europe. If you want to discuss Europe, I mean the European Union, sorry, you need to explain to people how it works. I don't know if you have seen in your newspaper, there was a lot of explanations before the European elections how Europe works. I think we have to do the same kind of exercise with complex technologies. We have to explain all the aspects from technology to legal and ethical. So having an informed debate is really important.
Thank you very much. Please, question from the audience.
Hi. Thank you very much for this discussion. It has been really an exciting panel. I think that's probably 45 minutes ago, Lisa said something like that she's not very confident that you can be equally successful with regulating artificial intelligence than with GDPR, for example. I think this is the key point. I think that's the regulating about ethical behaviors or ethical values is very complicated, because ethical values are not universal, right? What is ethical in one part of the world is not in a different part. And really, so I think one question is how effective could be really a regional, to develop a regional approach on this, even if you can develop a solid regional approach, what is also a challenge, because some values are not also pan-European. Because if you speak about Europe as something bigger than just the European Union, is a challenge. And so this is one one comment. The other comment is that I think, yes, there are a lot of decisions that are being taken based on artificial intelligence tools for recruiting people, for shortened lists of applicants to many positions, and for many other things. The problem here is not only the ethical behavior, is the incompetence and the biases. And regulating biases is complicated. If you, there is I could use, I will not take much of your time, but there are very, very interesting examples of biases. If you search on in search engine about some things like babies or something, that probably the result that you will get is not representative of all the diversity of the world. And a very simple question as do you know, I don't know, when was the last time the chairman won the World Cup on soccer? What everybody will think is about the main championship. So, but there are many other categories that are competing. So you are not thinking about the women championship or the people with disabilities or many other things. And if I challenge you, try that. It's a very simple question. And this is something that we are seeing every day on things that's decisions that are taken based on artificial intelligence. And this is a big challenge. Thank you.
Thank you very much. We must now, I think, come to a close. I'll have a comment by Joanne, and then I would like to ask our rapporteur to come here, after which I'll give one sentence to everyone. Please, Joanne.
I think the last speaker made an important point. If one looks at AI, though, very neutrally, one can also say, I'm just giving the example of AI, it also has the possibility, when done well, to reduce bias and discrimination. Because humans also, in our own decisions about who to recruit, we have a lot of bias and discrimination, as we all know. But of course, the quality of any algorithm is as good as the data that's put into it or the design of the algorithm. So from how engineers are trained, technicians are trained, to have all those life cycle stages where we say, are we thinking at potential bias and discrimination? But that's not forgetting that even without AI, there's a lot of bias and discrimination in everyday life. The police can also have discriminatory behaviour not using Pred, Poll or some other tool that's out there. We know that exists. So I think we can also be optimistic that AI, as an example, can also do good in a rights framing. Because a lot of this discussion has been about the negative side. There's also the very positive side, but for that you need the oversight, the checks and balances. We only mentioned children. I'm glad you mentioned persons with disabilities or the elderly and many, many other groups. And we can all experience bias and discrimination too. So I think, one has to be cautious when we look at saying AI is discriminatory and biased. A lot of the examples that have emerged saying, yes, it is. But also everyday human practice without the use of AI is also bias and discriminatory. And we need to advance AI to recognise those bias and discrimination. And that's one area where there's a lot written on rights and AI is bias and discrimination. So I think I just want to underline that point, though. We have to move forward with what we know to try and improve the AI tools that are out there.
Thank you. Before we're all being kicked out of this building, I'll give the floor to our rapporteur, Clément Perrano. Please, Clément.
Sure. So I have the difficult and ambitious task to summarize the key messages from this very comprehensive session. So I will read them to you and then see if the panelists and the audience agree in view for the adoption. So I have articulated the messages in around three topics: regulation models and frameworks, enforcement mechanisms, and literacy. For the first key message, all stakeholders, including private sector, agree that a form of regulation concerning the use of digital technologies is needed to protect individuals, build public trust, and advance social and economic development. But divides remain on, the scope and the bindingness of such regulation. Though there is a shared understanding that such regulation should ensure predictability and legal certainty. But there is a consensus on the need to initiate open-ended and inclusive debates to provide guidance and introduce frameworks to address the significant, the exercise of human rights by individuals, for instance, in the context of product development. When it comes to enforcement mechanism, states should take appropriate measures to ensure the effective legal guarantees and that authorities have the sufficient resources available to enforce human rights online of individuals and in particular for marginalized groups like children. There is a need for enforcement mechanisms within national law to ensure that responsibilities for the adverse risk and harms for individuals' rights are rightly allocated, for instance, by using impact assessment as we have seen previously. And when it comes to literacy, due to the power asymmetry between those who develop the technologies and those who are actually subject to them, there is a need to empower users by promoting digital literacy skills and enhance public awareness about the interference of emergent technologies such as AI with human rights. And that's about it. I would like to know if anyone in the room disagree, raise your hands.
I think you're putting a big challenge here, but thank you very much, Clément Pernaut.
Hang on, 1 second. I do have one comment though, because I thought overall you did an amazing job. That's almost impossible. But there was one aspect that I strongly disagree, and I think actually we disagreed with on the panel as well. And that was when you talked about enforcement, you stressed national law. And I actually thought you were going in that direction, but you were talking about national agencies for supervision and enforcement, not about the national law. I think the laws have to be ideally transnational, international, completely, or at least regional.
Absolutely. I must end it here because I've been giving a clear signal that this room will be closed, I think, in a moment. So I would give one sentence to each of you to close. 20 seconds. Please. Sorry.
I would say, reacting to the last intervention, that we should build on our European values to build the right framework for trustworthy AI, and we should do that together, indeed, at European level when it comes to the European Union.
I would like to give 3 takeaways. I think Europe has a great advantage. We're very advanced on GDPR and privacy in relation both to AI and other emerging technologies. I think we need a multi-stakeholder model to look into AI and the impacts there. And last, we should avoid any fragmentation of the European market.
Okay, I think basic message is we need the same rights online as we have offline, and we have to remember that we do have very robust human rights, fundamental rights legislation that exists that can be looked at and see how it is fit for purpose as we go forward with emerging technologies.
I would like to sign up wholeheartedly to what Joanna just said. We need to remember that we've got cornerstones in place. We've got cornerstones in human rights law. We've got cornerstones in experience. And if we build on those, we're going in the right direction. If we question everything every time somebody calls something a new or emerging technology or gives it a shiny new name, then we'll never get to our destination.
So thanks, first of all, for the organizers. I thought it was a really good conversation, actually. I want to come back to my first point, that the internet is actually one of the greatest inventions ever made, and we seem to kind of put it all in the bad place right now. There are big challenges, but it's also an enormous opportunity and has brought us really much progress. Thank you very much for the last question. I thought that gives me a great opportunity. Bias in the data set is absolutely crucial to address, and there is a big question. Do you you want to represent reality, or do you want to represent an ideal state? And especially when it is the second, I think we should be clear about what our tools are doing. I think a search engine should most of the time represent reality and not try to be a normative instrument. A place where we can really negotiate and deliberate and find out what the truth is a place like Wikipedia, where you have the transparency and you know, and there is an infrastructure for that. So Wikidata would be a place to think about that. So thanks again, great discussion, very nice.
Thank you very much. Thank you all thank the panelists, first of all, my co-moderator, thank the audience. We still may be confused, but I suppose we're confused at a higher level now. May I have a round of applause for our panelists? Thank you all very much. And see you all tomorrow. Thank you.
Thank you very much. Some very, very quick household communications, because the buses already are leaving for the beach. And the last bus will go on 7:30. So keep in mind. And tomorrow morning we start at 9, so don't drink too much. And we have a small present for you, so don't leave yet. Thank you very much.